Welcome to Colonie TV, the governmental educational channel for the town of Colonie.
Okay, the last time I was here, I don't know who was here at the time, I spoke on the book The Scorpions, which was the great book. I don't know authors, by the way, I forget who they are, and people always remember that. And that was a book about the four great Supreme Court justices of the 30s, 40s, 50s, and it went beyond. Black, Douglas, Frankfurter, and Jackson. Jackson was an Albany Law School graduate. This book, The Oath, is by Jeffrey Toobin. Many of you may have seen him. He comments, I think, on MSNBC or something. So before you read the book, you may know this, he's an unabashed liberal. Toobin really, I don't even know if he makes any apologies for it, makes no excuses, and doesn't try and hide it. So when you read the book, he wrote the book called The Nine about the Supreme Court judges. And now he's written the book, The Oath, and it's clearly from a liberal bias. So if you're anti-liberal, or if you really don't like the liberals in the Supreme Court, then you're probably not going to like this book. Now, if you go back a little way in history, in terms of book, back in the mid-'70s, before the mid-'70s, nobody ever really talked about the inner workings of the Supreme Court. It was always kind of a big secret and everything. And then in the 1970s, and again, I forget who the author was, and if you want to ask questions along the way, feel free to do that. There's a book called The Brethren. I don't know if Woodward wrote that or who wrote it. And that was about the Supreme Court at the time, and about the number of judges and their personalities and so forth. Now, of course, we have much more of an interest in the Supreme Court, and we should, because one person can influence our life. Take Obamacare, 5-4. That vote goes the other way. Citizens United, all the stuff about the billions of dollars in advertising, 5-4. Those are big cases. The average age, I don't know what the average age of the Supreme Court is, but if you take the Supreme Court now, and many of you may know this, and if you do, I'm sorry, but they don't retire in the Supreme Court. They're like popes. There's no such thing as a former pope, apparently. They never retire. Well, the Supreme Court judges lived till, Stevens, who retired a couple of years ago, was 90. So they will stay 80s, 90s. Rehnquist stayed well into his 80s. You have a number of judges today who are up there. They're not old, they're not young either. Scalia, for example, I think is 76. Kennedy's in his 70s. Ginsburg is 78, Breyer I think is 75. So you've got four judges, Thomas I think in his early 70s. So it's very likely in the next Supreme Court that Obama is going to appoint one, if not two judges to the Supreme Court. Now what they've learned over the last several years, Bush learned it, and now Obama's done it, is they don't just appoint anybody, they appoint somebody who's about 22, so they'll be there for 90 years. So when they appoint these judges, and they used to appoint people, again, like the popes, and I'm Catholic, so this is an anti-Catholic thing, when they figure that no one's going to give them a hard time, they'll elect somebody who's 70, which they did with John the 23rd, and they found out, oh my God, he actually is going to change this place. The Supreme Court gets appointed now by presidents who now want to make sure that, where in the past you'd appoint someone who was 60, 65. Now they're being appointed in their 50s, 40s. Roberts and Alito are both young. Kagan, I think, is in her late 40s. Sotomayor is in her early mid-50s. These judges could be there for 30 years, and that's 30 years from now. And so you've got a tremendous influence now by young judges who can stay in the Supreme Court forever. I forget who the judge was. Harlan once said, change one judge and you change the world, which is really true. Now, in the Supreme Court now, as most of you know, there are 9 judges. And there's generally 4 judges who are to the right, Roberts, Scalia, Thomas, and Alito. To the other side, you have Breyer, Ginsburg, Sotomayor, and Kagan. Kennedy is generally considered the swing vote. The basis of the oath, the name of the book, is that in 2008, when the oath was administered by Roberts to Obama, he screwed it up, and he didn't get the words right. And everybody got all Twitter, and, is Obama really the president? And, what are we going to do? And so they called Roberts, and they said, you got to come back. And so one night, you can just imagine the Chief Justice of the Supreme Court driving over to the White House and administering the new oath of office to Obama. Now, what's interesting a little bit about this, and they talk about Roberts, is that Roberts, like many of the judges of the Supreme Court, is phenomenally intelligent. I think he went to Princeton, Harvard Law School, came from a very, very cultured background, and prides himself on speaking without notes, prides himself on giving long lectures or whatever, and virtually, and he said this in the past, people remark on this, that he will not even look at a note. So it's funny when he gave the oath that he didn't get it right. He also is considered to be the best writer on the Supreme Court. Now, when you take the Supreme Court, like many judges, it became kind of a racial thing in the past, like Thurgood Marshall. Thurgood Marshall, as pointed out in the Brethren, in his last 10 years, was, of course, one of the great liberal judges of the Supreme Court. But Marshall, in his last 10 years, was basically a vote. He would sit there and, he would take a liberal position, unlike Brennan, who was much more active. But he was that vote. And the clerks did a lot of the work for him. They, according to the Brethren and other people, they'd pen an opinion in front of him. He'd say reverse. They'd write the opinion. He'd stamp it. It depends on the judge. Some judges obviously are much more active in writing their opinions, and that's true here in the Appellate Division in Albany, the Court of Appeals, and the Supreme Court. Roberts, you can always tell his writing because he has a gift. Some judges in the Supreme Court, even though a lot of the clerks may write their opinions, will write opinions that are incomprehensible. And you're trying to figure out what they're saying. And the other problem is, you will have, and this happens, you have 9 judges in the Supreme Court, you will sometimes have an opinion, a majority opinion, in which there are more opinions in the case than there are judges. So you say, well, how can that be? There are 9 judges, because you will have the majority opinion joined in by, say, 4 others. That's 5. You will then have concurring opinions and dissenting opinions on, say, part of the opinion. You'll now have the dissenting opinions of the 4, and you'll have 4 dissents concurring in part of it. Well, you can imagine the chaos that occurs later when you've got 20 opinions trying to figure out exactly what it is they're saying. The appointments, let me talk a little bit about the appointments, as you may know. The appointment process of the United States Supreme Court really, in this country, is really, I can't say it's a joke, but it's really scandalous, because the judges lie on their appointments. They really do. Ever since really the late 80s, when Robert Bork was nominated by Bush to go on the Supreme Court, and Senator Kennedy and the liberals went after him, and he had written a lot. He'd been a Solicitor General, and he'd been at Yale Law School, so he was an arch conservative. They attacked him, and it was a vicious, if you remember, public hearings, and Bork would sit there. Bork was not one who was going to shy away from what he wrote. So they'd say to him, well, no, you said this, Judge Bork. That's what I said, and that's what I meant. And then they accused him of back alley abortions, which he said, I don't agree with. That's not true. You misstated it. He ultimately had his name withdrawn. But that became one of the first really contentious hearings, and there had been some before that, on the nomination of the Supreme Court. Well, if you're going to be nominated for the Supreme Court, you're not an idiot. So you learn that any contentious positions you may have had in the past, you're not exactly going to confirm that. So Sotomayor, for example, had said when she was a judge on the Second Circuit that she thought a person of Hispanic background, which she is, the first one in the United States, would bring, and a woman would lend a great deal of balance and a new kind of thinking to the Supreme Court, and that that kind of person was uniquely qualified to sit on the Supreme Court based upon their heritage. Well, you can imagine what the conservatives did when they saw that, and her name appears. Well, all of a sudden, Judge Sotomayor said, well, I don't really think that. And maybe I said that, but I really don't agree with it, which is untrue. But it's no different than the other 8 who have sat there. So take the great questions of the day, abortion, which is still, I think, one of the hot button issues. And any judge in the last 20 years who has been nominated for the Supreme Court of the United States, they are asked this question: what are your views with regard to Roe versus Wade, which is a great country. Great meaning it was a landmark case in 1972. And the first thing they will say is, well, the case, I haven't had this case in front of me, so I really can't comment on it. And in any event, I really don't have an opinion, which is a lie. I mean, it's a flat out lie. Because they know if they say, yeah, you know what, Roe v. Wade comes up to me again, there's no way I'm reversing this case. What are you, crazy? Half the Senate applaud it, but you've got a major fight. So the next time you see a judge going on the Supreme Court, they will dilute all of their opinions because they have one goal only, and that is to get through the nomination process. They are vetted. They will sit down, whomever the geniuses are who will sit down, inevitably young, and they'll say, Judge, you can say this, you can't say that. They will go through their opinions. You have to be careful about this. Take Citizens United, which is a public financing. Judge, what do you think about Citizens United? Gee, that's a good point. I really haven't thought about it. Does any rational person believe that this person who's going to be nominated for the Supreme Court has not thought about that issue? And if they haven't, they shouldn't be on the Supreme Court. But that's the process we go through. Now, the person, Roberts, went through rather quickly. He was nominated by President Bush to succeed Rehnquist. And Rehnquist was one of the arch conservatives, as many of you know, on the Supreme Court. A lot of people would tell you that Rehnquist was nothing more than a crypto racist. You take some of, now, Toobin would absolutely agree with that statement. One of the problems you have with the oath, but if you know ahead of time what you're reading, is this. Toobin takes the position, really, that when he talks about Kagan, who was from the Midwest and her great background, and Sotomayor, and had this tremendous upbringing, and a family had been broken, and Hispanics, and had risen from the depths of the poverty. Ginsburg, a Jewish woman, and he lionizes all the people on the left, Breyer. And then he goes to the right, and he's got nothing good to say, perhaps begrudging people on the right. Doesn't like Thomas, Scalia. You can imagine what he says about Scalia. Kennedy, he says, actually, if you want a good line about Kennedy, he talks about Kennedy, the swing vote. And and he talks about how Kennedy, just for some reason, the First Amendment was, he just has this thing about the First Amendment that he just loves. And he says, but Kennedy had an almost Pavlovian receptivity to arguments that the government had unduly restricted freedom of speech, especially in the area of campaign finance. Throughout his long tenure, Kennedy had dissented, often in strident terms, when his colleagues upheld regulations in that area. And as the possessor of probably the biggest ego on the court, parentheses, always a hotly contested designation among the justices. So he humanizes some of the judges there, and he strips away, in large part, this idea that the 9 judges are sitting there and they have no political agenda and they're reaching these decisions on the merits. As he points out, when you look at the Supreme Court opinions, say in the fall, now, you'll see a lot of 8-1 and 9-0 opinions because they take a lot of the easiest cases first in the term. People can agree, they write the opinion, there may be a concurring opinion, no big deal. By June, they are absolutely trying to kill each other. And as he points out, by the end of the term, they just want to get away from everybody because the fights, the arguments, the bitterness, the person in whatever court it is who's dissenting continues getting beaten down. That's why you'll see these 5-4 decisions coming down so much at the end. Citizens United, Obamacare, and a lot of these other decisions, the gun cases, by then the judges have really dug in. Now, all the judges, you can judge for yourself, every judge now who is on the Supreme Court of the United States has an Ivy League background, law school. So the question is, how much are they in tune with the rest of the world? Harvard, Yale, there may be one from Columbia, nobody else. So the 9 judges, you want to talk about being inbred, that's where they're from. All the clerks who are very bright are from the top law schools in the country. Texas, Stanford, Harvard, Yale, all those kinds of things. Which brings up the famous line of Lyndon Johnson. When Lyndon Johnson came to Sam Rayburn, and he said, when he was first vice president, he said, you know, Mr. Sam, this is really something. He said, oh, these men now with Kennedy, you know, they're from Harvard, they're from Yale, they're from Ford, they're from the top corporations. These are the brightest people, which is the best and the brightest. That's where it came from. And Rayburn looks at him and says, that may be right, Lyndon, but there ain't a damn sheriff among them, which is very interesting, because that's what happened in Vietnam. There wasn't anybody who wasn't part of that group, which is part of what you're seeing in the Supreme Court. You're having people who share the same background. A couple of years ago, there was someone who was potential nomination by Obama from, I think had been educated at the University of Montana. And of course, there's a certain sniff of arrogance in Toobin and some of the other people, and that is Montana. Why would we put someone on the Supreme Court from Montana? Forgetting, of course, that some of the greatest justices of our Supreme Court, Robert Jackson, who never graduated from law school, and most people will consider one of the 2 or 3 greatest judges of the 20th century, and gone to Albany Law and dropped out. So you have a certain part of that comes through this book a little bit. Now, the book is divided, every judge, there's a chapter devoted to the judges. The book itself is well written. Toobin can write. He's interesting, he's funny, he'll take shots at judges who of course cannot respond in kind, and he gives you an insight, because I think he's actually a former Supreme Court clerk himself, as to the workings of the Supreme Court. The most arrogant people in the world, by the way, are the Supreme Court clerks. They have not no respect, but of course they always know more than the judges. They're the people who are talking to the press, leaking things out, and later they're the ones who will tell you how poor the judges are, and that only they could have been on the Supreme Court. Well, ultimately they do get on the Supreme Court, so we just keep revolving that kind of, or rotating that kind of opinion. Roberts, as you know, is the chief. Now, he's pretty interesting. If you remember, let me start off first with Obamacare. Obamacare, and he discusses, what's good about him in this book, he doesn't discuss arcane legal issues. But he'll give you, like the gun issue case, the Citizens United, the financing case, and Obamacare, the 3 big cases, he gives you a little background so you get an insight into what the arguments were about. And Obamacare, when it got passed or was in Congress, no one ever considered at that time that it might be unconstitutional. There were a lot of fights about whether it could apply, but on the Commerce Clause, no one really gave it much thought until later someone said, you know what, there may be a valid argument here. Then he traces back a certain view of the Constitution that is shared by Scalia and basically Thomas. And that's what's called literalism, that the Constitution is based really upon the literal terms. If you want to know what the Constitution says, or what a decision should be, you really go back and look to the plain language of the Constitution, and that will tell you exactly how the issue is to be decided. If you take the liberal viewpoint, the Constitution is constantly evolving, constantly changing, and who can possibly determine, for example, what George Washington or Thomas Jefferson thought about cell phones. Now, if you were Scalia or Thomas, they would say, well, you look at the Fourth Amendment, you look at searches, and we can tell you what he would have thought about cell phones because it says right there about searches and seizures. So what happens in a case like Obamacare, obviously, is a highly political case. You got the 4 liberals, everybody knew where they were going. You got 3 conservatives, Thomas or Alito, who was the farthest right of anybody, or furthest right, Scalia, Alito, and Thomas. Kennedy was considered to be the swing vote. Now, you're going to hear in the press that Kennedy's a swing vote, and of course, you know, Anthony Kennedy says, well, I will do my best. Well, according to Toobin, that's a fraud. He loves being the swing vote. He lives for that idea. He loves the press paying attention to him. He plays that up. That's his big thing, that I'm the swing vote. No one figures on Roberts, because everybody figures that Roberts is going with the conservatives. He's got a conservative background. He's got a conservative thinking. Some of the cases coming up now, you're right, you see some of his opinions, which can be very, very far to the right. Everybody figures that Roberts is going this way. But a couple of things happen. Roberts begins to think, according to Toobin, about his place in history. And he mentions this again. Anybody doesn't think that they wake up in the morning and think about what history is going to think about him is crazy. And he begins to think, well, I'm not really crazy about this statute, about this 400 pages, but if I overturn this, it's going to be so grossly political that forever after I'm going to be branded as nothing more than a tool of the Republican Party. Now, let's go back, if we will, to Bush versus Gore, which we all know about. When the Supreme Court, as many of you know, renders an opinion, inevitably, like you were to take Miranda, or you were to take the gun case, I forget the name of the gun case, it's in here, but take Citizens United or take Obamacare, the next term, that'll be quoted 3, 4, 5 times, and you'll have hundreds of citations to it. And they say, we said in this case, whatever. Bush v. Gore was decided in 2000. Has never been cited ever in the Supreme Court. Ever. The most important case of the Supreme Court in the last 50 years, it tells you what they thought about it. They never cited it. So if you want to take a political decision, there you are. 5 Republicans, 4 Democrats. Had someone else died during Clinton's term, Gore would have been the President of the United States. And Scalia, when they ask him questions, now says, get over it. But it was that simple. It's just nothing but pure politics. And when you look at that, although O'Connor later may have had some questions about that. But anyway, so it's 5-4. So now, here comes Obamacare. And everybody's looking at Kennedy, figuring he's going to be the swing. Whereas Toobin points out, Kennedy was absolutely going with the right on this. Roberts, in conference, tells people he's going with Obama. Now, the big argument in the case was the Commerce Clause. Could Congress compel people to buy insurance? And you may know, this whole broccoli business, you remember Scalia brings up broccoli. Can you force people to buy broccoli if they don't want to buy broccoli? Roberts comes on the argument, though, and seizes on the argument that, in fact, they're not going to affirm it on the Commerce Clause. What he will do is he will affirm or he will find the statute valid on the taxing power of Congress, even though Congress specifically said this is not a tax. And there became a big argument, which is kind of fascinating when you read about this. Is it a penalty or is it a tax? Scalia points out in the dissent, if it's a tax, then the statute's unconstitutional because you can only determine whether a statute is constitutional when the tax comes into existence. And this didn't come in until 2014. So Scalia, and the conservative view is, we don't even reach this decision until 2014 because you can't even challenge it at the time, because if that's a tax, you can't do anything until people start getting taxed, and it doesn't come in until 2014. And what he says is basically a penalty, and it's unconstitutional. Roberts goes with the left, Scalia goes wild. Absolutely goes nuts. And what they do, which is very unusual in the Supreme Court, the clerks begin to leak to the press which way the vote is going. Now, one thing the Supreme Court has always done a good job in the past, there are very few leaks from the Supreme Court when a decision is being debated. That's not to say people may not talk, but you usually don't have a lot of discussion outwardly as to which way they're going. The clerks, on behalf of Thomas and Scalia, are now leaking to the press. Why? Until they sign off on that opinion, and the number of times when you will have a judge who will change at the end, you have tremendous lobbying going on, where the majority can flip to the dissent and vice versa in a minute. Until they actually issue that opinion, what can happen is, if they can change that vote, now what would happen with Roberts in that case might, if he wanted to switch, he goes over, he just joins there, the dissent becomes the majority and so forth. The idea was to force his hand, to publicly start to put a tremendous amount of pressure on Roberts to force him to join the right. Didn't do it. Why he didn't do it? I mean, obviously, if you were to take his opinion, he would say, I did it as a matter of conscience. If you were to take Toobin's idea, he did it because he wanted to make himself look good and to appear to be somewhat impartial. Whatever the reason, that's the decision. And the reality of it is, these judges, as I said before, are motivated by politics. Anybody who thinks that they're not is crazy. Let's not forget something. They're all nominated by judges, by presidents who have been given the idea, are they safe? And they're a lot safer now than they used to be. Let me give you a couple of examples of judges who've turned out not to be safe. Dwight Eisenhower said the worst mistake he ever made was appointing William Brennan to the United States Supreme Court. Not only did Brennan turn out to be a liberal, but he was there for 35 years. And he was like 55 when he appointed him. In 1976, the Ford nominated John Paul Stevens from Illinois to the Supreme Court of the United States. Stevens turned out to be one of the great liberal judges, or one of the real liberal judges of the United States Supreme Court. Then in 1988, I think, John Sununu, who was the chief of staff for Bush, comes to Bush and says, listen, I've got just a man to appoint here, David Souter from New Hampshire, who's a good friend of mine, a Harvard man. So they appoint Souter, who also turns out to be a real liberal. Souter's kind of interesting because liberals, he used to drive an old car, became quite wealthy, but never cared about the trappings of office. But he was very clearly to the left. But he was a bachelor. And as someone once noted, that's what Bush gets for appointing a man who lives in the woods with his mother. And Souter and Stevens formed a very strong bond on the liberal side of the court. We all know about the Warren Court, or the Warren Court. Many of you know Earl Warren headed that court in the 50s and 60s. When Nixon became president, the move in the country and the movement in the country began to turn to the right. So at that time, Nixon appointed Berger, he appointed Rehnquist, he appointed Powell and some other judges. Then in the 80s, when Reagan came into office, and then Bush, the voice, really the hard voice of the conservative vote was Rehnquist, but the real edgy voice was appointed not Bork, but Antonin Scalia. Now, Antonin Scalia, if you're a conservative, is perhaps the greatest justice of the last 100 years. If you're a conservative, he can write, especially his dissents. He's a very strong advocate in the bench. He asks a lot of questions. He's got an ego that's enormous. Doesn't mind telling everybody that, lets everybody know how smart he is. If you're a conservative, Nino is your man. If you're a liberal, there is nobody more hated. If the liberals absolutely hate Scalia and everything about Scalia. So you've got something. Now, the one thing about Scalia is he doesn't back down. He will write opinions which will deliberately inflame people just because that may be Scalia. He's older now. And as Toobin points out, as people get older, those rough edges that you have in your personality, they begin to go to a little more coarse. And so Scalia's questions oftentimes will be very sarcastic. He takes people on the bench, but he's a voice. And he leads the conservative element of the court. He does not, one problem Scalia has, like many zealot or strong advocates, he does not build coalitions. Scalia is not interested in that. He's interested in his point of view. He has a basic contempt for Congress in cases that he doesn't like or a statute he doesn't like. He cares about winning, of course he cares, but he is not someone who is going to sit down like a Brennan did, or someone else might, maybe even Roberts, and work. When you build these coalitions in some of these cases, it takes a lot of work. When the Supreme Court, well, let me tell you, for those of you who may not know, when a case comes up before the Supreme Court, if they decide to take the case, certain cases they will take automatically. If they take a case, say a case of confessions, or a search case, or a tax case, it comes to the Supreme Court, and it's a rule of the four judges have to agree to take the case. And one of the real great issues in the constitutional history became, in the 1960s, Douglas and Brennan, and I forget one other judge, kept arguing to take the Vietnam War cases on the constitutionality, whether we were constitutionally in Vietnam, whether we were actually at war. And the Supreme Court never touched that case. They didn't want to, for political reasons, which probably was smart, and said, listen, you're not going to tell the President of the United States and Congress to pull all your troops out of Vietnam. So you have to get four judges to agree. Now, if they do, it's called certiorari. The case then comes up to the Supreme Court, and it gets briefed by the appellant, the appellee. If the government is involved in a case, then acting on behalf of the government is a body known as the Solicitor General. And the Solicitor General argues cases on the constitutionality of statutes on behalf of the Supreme Court of the United States because they're appearing on behalf of Congress and the President. And that's a very powerful position. Some of the great judges, I think Kagan had been a Solicitor General. Very highly respected by the Supreme Court. And one reason why they're highly respected is because the advocates who come in do not do so with a political basis. So, for example, you may have a Solicitor General, Congress has passed a statute that we are going to now kill 9-year-olds, or execute 9-year-olds, or we're going to pass a statute that we can execute people for robberies. The Solicitor General's office does not make an independent moral judgment as to whether it's a good law or whether it's a bad law. When they appear before the Supreme Court on behalf of the government, they're arguing that a statute, as written by Congress and passed by the President, is in fact constitutional. And because of that, you will have attorneys who will argue a cause passionately without regard to whether or not they truly believe in it. Now, that doesn't make them dishonest. It means that that is their role. And the Supreme Court acknowledges that, and they have a great, as I say, a great amount of respect for people who come in to do that. That's why you might have a Solicitor General arguing one position before one president, and 5 years later arguing something different. That's their role. Now, when a case comes to the Supreme Court, and all the briefs are to the judges will read them, and they'll have all kinds of discussions, and maybe the clerks will come in and talk to them. And the clerks are appointed by the judges. I think there are 4 judges. Rehnquist, I believe, in the 30 years in the Supreme Court, I know this, he never hired an African-American, not once in 30 years. He couldn't find an African-American that he thought should sit as one of his clerks. I don't think he ever hired an Asian, and it took him a while, I think, before he got around to thinking that women should be a clerk. So that was William Rehnquist's idea of how he wanted to run his office. After the argument, and what's interesting about the Supreme Court is you think of these huge courts where the people are outside and they're 10, 15 feet away. The court actually is very small. And so where this gentleman is sitting in front of me in the Supreme Court, that's about how close you are to arguing. They're right on top of the attorneys. And the judges have been briefed, and these are very bright judges, whichever side they're on. And oral argument typically may take a half an hour, 45 minutes. The Obama case was different. It was unusual. It took 3 days. And they will start peppering people with questions, the attorneys. Thomas has not asked a question in 7 years. In 7 years, he has not asked a question. His idea is, well, I'm wanting the lawyers. And the judges can really interrupt the arguments. It is not unusual at all or unknown or surprising for an attorney to stand up and say, hi, my name is Steve Coffey. Mr. Coffey, you don't even get their name out. And the whole hour, half an hour you have, you're just getting peppered with questions. After the argument, the judges will get together, they will meet, and they will then vote on a case. Now, the person in the majority who is senior, the oldest seniority, will appoint who's ever going to write the opinion. Same with the dissent. So, except the Chief Justice. Chief Justice always has seniority. So the Chief Justice can always assign a case to himself. But if the Chief Justice were in dissent, say, and there were 5 in the majority, then I believe Scalia would be the senior judge, and he would appoint whomever he wanted to write the majority opinion. Rehnquist was very careful in not assigning a lot of majority opinions to Scalia, because Rehnquist, it was as conservative as Scalia, but Rehnquist had a better sense of how he had to frame compromises and have a coalition. And he knew that if Scalia started writing his majority opinions, that you could have something come out that would really be inflammatory. Now in dissent, you write whatever you want. I mean, it doesn't make a difference. No one cares. I mean, they care, but I mean, no one, you may be told you're going to write the dissent, but someone else can write a dissent along with that. Roberts, who is conservative, is joined by Scalia and Thomas. Now, Thomas is pretty interesting. You may remember Anita Hill. And Anita Hill has become one of the great moments in American history for primarily this reason. Prior to 1994, domestic violence in the United States was an issue, but it wasn't a hot-button issue in the courts. So what happened in 1994? OJ. And what happens in OJ? Remember those recordings? She's calling up the police, New Year's Eve. You know who it is. He's been here before. It's OJ. And all the domestic violence, a lot of it, now the courts begin to look at this and said, oh my God, because he was famous, because he's rich, because he's O.J. Simpson, changed a lot in this country. Harassment in the workplace, men got away with it, got away with a lot of it. Anita Hill changed a lot of thinking in this country. The conservative hater, that may be. But a lot of the harassment, a lot of changes came by after the Anita Hill case with the idea that men, remember that the whole idea was that Clarence Thomas was attacking, harassing her, showing dirty pictures, saying, what do you come on, let's go. He said no, she said yes, who's to say? In any event, it changed a lot. So Thomas gets on the Supreme Court. He's an African American, and he turns out to be one of the real conservatives on the Supreme Court. But not only that, today, his wife, Ginny, is a leading member of the Tea Party. So it's interesting. And now, by the way, the liberals, if they had their turn, they do the same thing. So who are they kidding? But she is a real voice of the Tea Party. I mean, she's rabid. And they're very close. And of course, Thomas, what does he say? Well, my wife's opinions are her opinions. Well, that's absurd. They're married, they're close, they travel together, his views mirror her views. He is totally to the right, but he may not be as far to the right as Alito. Alito was a judge out of New Jersey, appointed by Bush, very bright, very far to the right. And Alito's got a little bit, not more, but he's got kind of a, I don't know if it's a nasty edge to him. You may remember about 2 or 3 years ago when Obama at the State of the Union gave a speech about the Supreme Court about how they'd passed a bill and Citizens United, and Alito started shaking his head. But Alito did something else which even other judges found to be somewhat, if not remarkable, somewhat distasteful. Roberts, after Obama was elected, reinstituted a reception that they had had in the past, and a practice they had in the past. They'd invite the President of the United States over to the Supreme Court for a cocktail party or for an hour or two. And so Obama came over, and Biden came over, and Alito boycotted the meeting. Now, if you're a liberal or conservative, I don't believe if you're a Supreme Court justice, when the President of the United States comes to a meeting, that you boycott a meeting. Whether you like his opinion, whether you like his views or not, that is a matter whether, and by the way, that was a meeting or a cocktail party set up by the chief. It wasn't set up by Obama. He wasn't inviting them to the White House. Obama was invited over to the Supreme Court chambers. Now let me mention something about Obama. In politics, and you talk about the talk show host, and they say Obama isn't that smart. Obama was a former editor-in-chief of the Harvard Law Review. And you don't get to be the editor-in-chief of the Harvard Law Review because of affirmative action. He was a good student. He was well-respected. He's a bright, bright man. May not agree with his views, but Barack Obama is a very bright man. And he's also a constitutional person. And what's very interesting, and Toobin points this out in his book, because we demonize people on the right and demonize people on the left, a lot of people think that Obama, as pointed out in this book, is so far left, and that he wants to point these people, these judges who are just going to take a wild position, when in fact that's not true. In fact, as he points out in this book, Obama is very much of a moderate on constitutional law. And when he's made 2 appointments, and he's made 2, Kagan and Sotomayor, you can imagine the kind of pressures put on him. You got to appoint this person, that person, and don't forget, we got to take care of the right. We need someone strong. That is not the way he views the Constitution. In fact, if you were to take Roberts' center right, Obama, as pointed out in this book, which I found interesting, is really center left. He's not far left. He's not as far left, for example, as Marshall would have been, or he's not as far left probably as maybe Breyer or Ginsburg. That is not the way he views the world. And so what's interesting about that, because that guides his appointments. Now, we always think of the Supreme Court controlling everything, and that is the ultimate voice. But in fact, the president makes appointments to the district court, which is down in Albany, and the federal courts of appeals. And 98% of all cases in this country are decided by the courts of appeals. Now, they may follow Supreme Court decisions, but you could be, for example, in the South, which has a very conservative Fifth Circuit Court of Appeals, come up north, and in fact, Roberts came out of I think the Fourth or Fifth Circuit, and you see these other circuits. D.C. Court of Appeals is very liberal. The president will be appointing people to these positions. Now, Senate has to approve it. There's tremendous influence by the president that he can exert over our society by his appointments, which isn't just the Supreme Court. So does anyone think that Obama is looking through the credentials of every man and woman who's being appointed to the Supreme Court or the Courts of Appeals? No, but his prevailing philosophy, known by his aides, is that he does not want people who are far to the left. And that's very important, because these are the kinds of people, you get appointed in the Court of Appeals, it's the same as the Supreme Court. You appoint a judge today, 45 years of age, that judge could be on there for 40 years. And in 40 years, you can exert a lot of influence. Courts of appeals have 3 judges who sit. So if you're there and you got 2 people on there going your way, unless the Supreme Court's telling you something else, they're going to decide that in, say, New York or Los Angeles or San Francisco or Atlanta. There's tremendous influence. Now, the left, when you look at the history of some of these judges, Breyer, Sotomayor, Ginsburg, and Kagan, what you have is when these judges had these cases come up, they're absolutely guided by politics. You hear this kind of fluff, well, the judges, you know, they go out there and they decide things based upon the law and everything else, but they don't have any outside influences. There's never been a claim on this court or any court before this that someone gets to these judges. I remember in the Brethren, there was a question then, Tom Clark had been a former judge, where he sat down with one of the Supreme Court judges and started talking about a case that he had lobbied on. And the judge was really offended by this. Douglas said, Tom, we're not going to do this. You're not going to start lobbying me in this case. So what you have now is a situation in which you have a shifting majority in terms of what Kennedy's going to do. You know, this year there's some big cases coming out this in the next term. Affirmative action. Can colleges, for example, look to the race of an individual in determining whether or not that person should be admitted to a university? A person who was very strong before that the colleges could look at that and universities could consider that was Justice O'Connor. And she's now gone. There's a great body of thought that had O'Connor sat on the Supreme Court when Citizens United. What the conservatives did in that court was to say there's no First Amendment, or the First Amendment precludes any kind of government control of spending in elections. Now, if that's your philosophy, fine, but you've seen what happens now with millions, billions of dollars being spent all through this country influence elections. That was a 5-4 vote. Alito was the 5th person coming in. He took O'Connor's place. O'Connor publicly said, if I were on that case, I would not have allowed, that statute to have been declared unconstitutional, because that was a McCain, whatever. There's 2 people who sponsored it. She said, I would affirm the constitutionality of that statute. Would that have changed this election? I don't know, but you can see how 1 vote changes a lot. And she was a very moderate voice. She's also someone who got along with people. Rehnquist was to the right. Rehnquist, in many ways, he liked her. They had some philosophical problems, but everybody liked O'Connor. Now you've got the Supreme Court, which is becoming even more divided. And you've got to the left, you've got to the right, and you don't have this mix in the middle. Now, I've gone till it's 1 o'clock. Yes. Yes.
Do you favor retirement from the Supreme Court, and at what age would you think would be a good time to retire?
Well, I'll give you one answer here, but if this were a younger crowd, I'd give another answer. I'm part of this crowd, by the way. Well, it's not going to happen, so they're not going to change it. Do I think that Supreme Court judges should be working into their 80s? No, I don't think that in your 80s you can still be sharp. Yes, but Stevens, for example, I mentioned, when he retired, he was always vibrant. And what they do is when they reach a decision, the judges will come out, they'll sit there, and it's not usual for a judge to issue, he may give a truncated, or she, copy of their opinion from the bench. Sometimes the judges are really mad. I think Ginsburg went on for half an hour. She was so angry at what the majority did. Well, Stevens, he was 90, and he was retiring, and he announced a decision at the end. Now, this is a man who had sat, and I like Stevens, during the entire term. And Toobin really softballed it and really coddled him and said, well, Stevens wasn't quite up to it. He was missing words. He was stumbling. He was fumbling around. You couldn't hear him. 2 weeks before that, he had a voice that was deciding some of the most important cases that affect all our lives. So at the age of 80, yeah, I think you can say that's enough, but it's not going to happen. You got to they're there for life. You got to amend the Constitution. And it's not going to happen. Speaking of amending the Constitution, one last thing, not last thing, before I forget, I saw the movie Lincoln the other night. I know you've seen this. It's really a phenomenal movie. Yes.
Why couldn't we amend the Constitution since it was written at a time that the lifespan of the men, the lifespan was like 46 or 48? You were very old then.
You could. You've got to either get Congress to pass it by 2/3 majority, or you've got to have the states pass it. And what's happened is no one's really inflamed by this because everybody has an interest in this. Over 80, there's no question that judges are infirm and they're making decisions. And the problem that I have with this, quite honestly, is the judges will come sit, and they talk about Marshall. And it almost sounded like you were being racist if you said this is a joke. Marshall at the end wasn't doing anything except sitting there. That's all he was doing. And he'd say, you know, reverse, whatever. And now your clerks are writing the opinions. And so in effect what you're doing is you're really placing the decisions in the hands of a 30-year-old. Now it's true they have a vote, but nonetheless the power of these clerks can be enormous, particularly as the judges get older. And not just the decision. When you want to know what a decision really stands for, don't look at the first decision, look at the second decision when they tell you what they really meant. So you get some clerks writing some of this stuff, and they're putting stuff in that opinion, some of the language. That language can be a real killer later. And the judges will say, I didn't realize this.
Could you please shed some light about the nominating process? Like, the president does not know all the people who are the proper candidates, so it must be going to local politicians, the names of the prospective candidates for Supreme Court.
He talks about this book, and I'll tell you the way that works. Someone, say, today dies or retires in the Supreme Court. Now, what's happened is the American Bar Association has now almost have a voice of saying we like them or don't, which I really have a problem with. I don't think the American Bar Association should be the last voice in anything. They can give an opinion, but the presidents will look to the American Bar and say, what do you think? You could have someone who some of the American Bar Association they don't like who's very qualified. But anyway, so now a person, and I'll give you a good example of this. He's now dead, so I can tell you the story. And this will be symptomatic. In 1987, there was an opening in the Supreme Court. And at that time, in Albany, there was a judge named Roger Minor. Now, Roger Minor was from Hudson, bright, articulate, and a Jew. Perfect, and conservative. Perfect for the Republican Party. Now you have someone Jewish who's conservative, New York, what more could you ask for? So I was talking about this once. And when the person dies, the president then gets like 5 or 6 names, and I talked before about Sununu. Because he was the chief of staff, he goes in and tells Bush, listen, this is who we should take, okay. But they'll vet them and they'll have 5, 6 names. And they point this out in the book that Kagan, there was somebody else named Woods, who's a judge in the Midwest, that Obama liked, but she may have been a little too liberal and he didn't want to get in a fight because that's not his style. And so a number of names will filter in and they'll vet them. You know, is she safe? Is he safe? You know, can they, so forth. So then probably 2 or 3 names come into the White House, and they call that the short list, if you've heard that. He's on the short list, and I think that was that phrase comes from. Minor is on the short list, which means he's one of 2 or 3 judges who have now gone to the Oval Office. And now what's happening, Bush is sitting there, what do you think, Harry? Mary, what do you think? And he gets knocked out on this basis. In the mid-'80s, there was an advocate, a pro-life person, who had taken a number of cases against the constitutionality of the abortion statute, of Roe v. Wade, or the statute. And he goes to the New York State Court of Appeals, and he gets He has no standing, meaning they're saying, listen, you're just a citizen. You don't have any right to be here. And they talk about standing in this book, which is pretty interesting. Can you bring the case? And they throw him out. He then brings a federal action. And Minor, at oral argument, says you have no basis for being here. You have no federal cause of action. You've been tossed out of New York, and I'm going to fine you for a frivolous lawsuit, which it was. He had no right to be there. Minor says later he gets knocked out of the Oval Office because they consider him not safe in abortions. So someone says he's not with us, and Minor said, I had the law in front of me. What am I going to do? Whether I agreed or not agreed with it, he had no basis for being there. So the names come into to the Oval Office. It's not like the old days when Roosevelt would call somebody up, and in fact, in the book, The Scorpions, he used to play cards with people. He'd be sitting next to Douglas, having a scotch and a cigarette and say, hey, Bill, it's going the right way, right? Well, yeah. Now you really do have a separation. He'll call someone up, they'll appoint him, and then really it gets pretty interesting because now the person gets appointed, and if you're a man, if you're a woman, if you're an Asian, if you're black, if you're white, if you're from Mars, you can be guaranteed that a third of the United States Senate is going to be against you, probably. And a third is going to be with you, and who knows where they are in the middle. And then they take you through the whole process. You start going up to the Hill, and you start meeting people. And you're John Roberts, and you're meeting Ted Kennedy, or Sam Alito, and they ask Judge, best of luck, and Kennedy's sitting there, and Alito hates Kennedy, and Kennedy hates Alito, and they both know they hate each other, but they got to do the dance. But you have senators sometimes in the middle. Now, it's 53-47, is it 55-45 now, the Senate? All right. They don't filibuster generally against a nominee. If someone's really bad, the Democrats will bolt, but for the most part, they'll get them through. And then they'll vet them. They'll sit them down, they'll go through the whole thing. Here's the questions going to be asked. And the senators, a lot of the senators are very bright, and they'll have good staff, so they'll ask them, Judge, what about this decision you wrote in 1991? And the judge will be expected to know that. And that's how that whole process works. The more the president has to lobby for his nominee, the worse it is. You got to hold your own. Now, if it were 55-45 Republicans, Democrats, that'd be a problem for Obama. They'd probably go along with somebody he wanted, but they'd make sure that he's in the middle. With 55, that woman he didn't appoint, I think her name was Woods, in Chicago, he gets an opening now. He may say, listen, I'm on the way out anyway. I'm appointing her. So that's how that process works. And they'll find out if you get any skeletons and that kind of stuff. Yes?
When the justices take the oath to uphold the Constitution, are they upholding the original Constitution or the one that they presume would be changed by modern influence? Well,
that's a very good point. In fact, I think I alluded to that in the beginning. If you were to take the position of judges, say Thomas, Scalia, I think Alito too, they would say our job is to uphold the Constitution as written, as passed, and as we understand it from 2,000 years ago. If you were to take the left, say the Warren Court or other courts, for example, this whole business, remember the Eighth Amendment question, the contraception? In the 1960s, Connecticut had a law that you couldn't have contraceptives, and it was illegal. Well, the Supreme Court of the United States came up with the right of privacy, that married couples have a right of privacy, and the state could not invade the right of privacy. And everybody said, where are you coming up with that? And they said, well, that's what the Constitution really meant. So it depends what your view is. Other people would say, no, I think it's what the Constitution, how it's evolved. In reality is, if you got the 5 votes, the Constitution is pretty much the way you say it is. And both sides argue about that. But that's really what it is.